A 7-year pursuit of litigation by a transgender person to effect changes to her birth certificate so as to reflect her new gender came to fruition on December 20th when the Karnataka High Court highlighted a lacuna in the law and directed authorities in the state to process her application. Born male, the 41-year-old had undergone a sex reassignment surgery several years ago and thereafter changed her name and gender in identity documents, such as Aadhaar, driving license and passport. But when she made an application for a change of name and gender in the birth certificate, local authorities cited Section 15 of the Registration of Births and Deaths Act, 1969, which did not provide for it. Currently, as per the law, there is no provision for any voluntary change in the birth certificate, not just for transgender persons, for anybody. The only thing you can do is either cancel or correct a name if there is a spelling error, says Aparna Mehrotra, an advocate with the New Delhi-based Center for Law and Policy Research, who argued for the petitioner. While people can change their names via rules framed by the states, their birth certificates cannot be amended. It affects everybody but transgender persons disproportionately, because for them legal documents often become the basis for identity, says Mehrotra, pointing out that the Transgender Persons Protection of Rights Act, 2019, was enacted precisely to protect their gender identity rights and welfare. The Transgender Persons Act specifies the permissions and sanctions for gender reassignment and the procedures to be followed for a certification of identity from the district magistrate after the transition. The petition in the High Court argued that an anomalous situation had resulted between the two laws, the Registration of Births and Deaths Act and the Transgender Persons Protection of Rights Act. While the birth certificate is among the identity documents that can be changed under the Transgender Persons Act, Section 15 of the Registration of Births and Deaths Act didn't allow voluntary changes to it. We wanted a direction from the High Court towards a change in the birth certificate. But we couldn't do it without challenging Section 15 of the Registration of Births and Deaths Act. It came in the way, says Mehrotra. The High Court observed that subsection 2 of Section 7 in the Transgender Persons Act provides for a certificate to be issued, which in turn would enable such a person to seek a change in name and gender in all identity documents. Subsection 3 of Section 7 provides for a change in the first name in the birth certificate. When subsections 2 and 3 provide for both change in gender and change in first name, the concomitants thereof would be issuance of a necessary birth certificate under the relevant provision, in this case, Section 15 of the Registration of Births and Deaths Act, the High Court ruling stated, noting that a revised birth certificate would have to be issued if all the requirements of the Transgender Persons Act are fulfilled. The government would have to carry out necessary amendments to the Act of 1969 and rules framed thereunder to give effect to the Transgender Act and establish necessary procedures required to be followed, to give effect to the purpose and intent and mandate of the special laws, namely the Transgender Act, the court observed. In his order, Justice Suraj Govindaraj said, until suitable amendments are made to the Act of 1969 and the rules framed thereunder, it shall be the duty of the Registrar of Births and Deaths to give effect to any certificate issued under Section 6 or 7 of the Transgender Persons Protection of Rights Act, 2019, by accepting and processing an application filed by a transgender, if accompanied by certificate under Section 6 or 7 of the Transgender Act, and make such entries in the Register of Births and Deaths and issue necessary birth or death certificate with modification made, indicating both the earlier name and the present name with the details of the certificate under Section 6 or 7 being incorporated in the said certificate. The order directed the local authorities in Karnataka to process the application of the petitioner within 4 weeks while also requesting the Karnataka Law Commission to suggest appropriate amendments to the Act of 1969 and the rules framed thereunder so as to give effect to the Transgender Act in its true letter and spirit, at the earliest.
Click on the link in the description to read more about the story. Don't forget to share the video and subscribe to Law Today for more updates about what is happening in courts across the country.